5 seconds to go. Start. Since technically on 4th November 2016, defendant was not proceeded ex parte, hence, in technical sense, the judgment cannot be said as an ex parte judgment, but actually this is an ex parte judgment as for all practical purpose defendant has been proceeded ex parte on 4th November 2016 when his DE was closed in his absence. Hence, I consider the judgment dated 8th November 2016 as ex parte judgment. Therefore, in my application under Order 9, Rule 13 CPC filed by the defendant is maintainable. Now coming to the merits, from the aforesaid order sheets, it is evident that the fact of defendant being in JC was intimated by the defendant's counsel on 22nd April 2016, and in fact thereafter learned predecessor has issued the production warrants on 11th May 2016 for production of the defendant from the jail, but he was not produced by the jail superintendent from Jaipur jail, and court has again directed to produce him for 8th June 2016. But in between, matter was transferred to the Honorable High Court and then again transferred to the District Court for 9th September 2016. On 9th September 2016, my learned predecessor was not sure that accused is in judicial custody. Therefore, she was asked for the affidavit of the counsel for the defendant regarding the defendant being still in judicial custody on 9 September 2016, and apparently same was not furnished when the case was listed on 4th November 2016. In fact, some proxy counsel appeared on behalf of applicant defendant on that day to apprise the status of defendant whether he was in JC or not, due to which court closed the DE as M number 264 of 17 Prakash Chand Goyal versus Messrs Garment Craft, page 8 of 9, averred by the defendant he was in JC and only released from jail on 6th May 2017. This fact has not been contradicted by the applicant plaintiff. Therefore, in my view, there was no fault for his non appearance for leading DE or not filing the list of witnesses, as same was beyond his control. The record shows that some proxy counsel might be appearing on his behalf, but when a person remains in jail, and that too in Jaipur jail, it becomes very difficult to give instructions to his counsel on each and every date. Even the counsel also become lethargic, as he might not be getting his fees. Therefore, even proxy counsel was not appeared on 4th November 2016, due to which DE was closed. Hence, in these circumstances, in my view, there is sufficient ground to set aside the order dated 4th November 2016 closing DE in the interest of justice. Stop.